Well, welcome. This presentation today is sponsored by California Litigation section of the California Lawyers Association, and we are delighted to welcome our three panelists to a presentation to talk about remote advocacy, whether it be in front of the court, in a mediation setting, or elsewhere, now that many more proceedings are happening online. And so we're really delighted to have you today. We do want to let you know that this session is being recorded and that you can submit questions by going to the chat box, which should be in your Zoom taskbar. And if you send a private message to Mary, so Mary McKelvey, she will be looking at those questions and we'll be posing some of those questions to our judges and justice at the end of the presentation. So please use that function if you'd like to send in a question. And with that, Mary, why don't you start the introductions?
That would be great, and thank you, Michelle. My name is Mary McKelvey, and I currently serve as an officer on the Executive Board of California Lawyers Association Litigation Section, and I serve also as the first Vice President for Women Lawyers Association of Los Angeles, and also serve as a partner at Polsidelli in the Los Angeles office. So I'm really pleased to be here today and to be co-moderating this panel with Michelle Galloway. And we have an amazing panel for you today, really exciting. I think you're going to enjoy this very much. We have Judge Beth Freeman, who is a United States District Judge, Court of the United States District Court for the Northern District of California. Judge Freeman began her career in private practice from 1979 to 1983. Then from 1983 to 2001, Judge Freeman served as the Deputy County Counsel at the San Mateo County Counsel's office. In 2001, she was appointed to the San Mateo County Superior Court as a Superior Court judge by Governor Davis, and she ultimately served as the presiding judge of that court from 2011 to 2012. On June 20th of 2013, President Obama nominated Judge Freeman to the Northern District Bench and then renominated her to that bench in January 2014. Asked to describe Judge Freeman by those who knew her, she has been described as a great mentor to many, and she's known for her deeply calm demeanor on the bench and for being incredibly well prepared both on the federal bench and on the Superior Court. She frequently shares her time and her support of local and the greater bars. And asked to describe her by those who know her, she has been succinctly described as, she's just an amazing lady, a real inspiration. So we're very, very happy to have her with us today.
We also welcome Justice Elizabeth A. Grimes. Justice Grimes was confirmed as an Associate Justice of the 2nd District Court of Appeal, Division 8 in April of 2010. She was appointed to the Los Angeles Superior Court in December 1997, where she sat in dependency, felony calendar courts, and independent calendar general jurisdiction civil courtrooms. Before that, she was an associate and partner with Gibson, Dunn & Crutcher from 1980 to 1998. She received her BA from the University of Texas at Austin and her JD from Stanford Law School. Asked to describe Justice Grimes, one of her colleagues responded, "I think what impresses me most about Justice Grimes is the eagerness and diligence that she continuously brings to legal education and judicial outreach. She constantly strives to elevate the practice of law for practitioners and the quality of judicial decision-making." Welcome, Justice Grimes.
We also have Judge Samuel Macadam. Judge Samuel Macadam currently serves as the presiding judge of Yolo County. He was appointed by Governor Schwarzenegger to the Yolo Superior County Court Bench in 2008. He's presided over every court calendar, including extended terms on the criminal, juvenile dependency, and family calendars. While serving on the bench, Judge Macadam also taught employment law for 5 years at Pacific McGeorge School of Law, and prior to his appointment, he was a partner at Sefrith Shaw, specializing in employment law. Judge Macadam was recommended highly as an ideal panelist for this particular panel, as he recently indicated that he had a quote-unquote strong opinion about attorneys appearing via video. We thought that qualified him very well. As a presiding judge, he's also dealt with all of the logistics of moving to remote, so he's very knowledgeable on that front and so much more. He's been described as one of the most approachable and kindest judges. He can always be counted on for a warm smile and a good joke. So welcome to this really powerful panel of judges that we have today. So before we get started, and thank you, I want to thank each one of you for agreeing to be here and taking your time, which is valuable on normal circumstances and extraordinarily valuable in these times. But we find ourselves quickly thrust into this world of remote technology by necessity, without any real planning or any real opportunity for forethought. And so I think it's helpful if we just take a moment before we begin and orient ourselves a little bit to provide some context for the discussion. Judge Macadam, can you talk to us for a moment about how we got here?
Great, yeah, thank you, Mary. Thank you for the introduction. And it's good to see everyone through Zoom Court. Wow, what an amazing 12 weeks it has been. It was March 16th, that Monday, when we had to really turn the corner, and the pandemic was right before us in California and right before the courts. And we had to make an immediate decision on how to stay open. We understand that some courts in California and throughout the country closed for a short period of time. We were fortunate in YOLO to make the decision to stay open and thought hard about how to do that. So when you ask the question how we got here, where is here? Here is the virtual courthouse. That's where we are right now. We're practicing law, we're making decisions in a virtual courthouse, and it's a great challenge. How we got here? Well, we obviously the pandemic and safety, and we had to reduce the footprint at the courthouse to keep our staff safe, to keep the courthouse community safe. We had to reduce the footprint. And how do you do that? Well, you do it through a virtual courthouse. We had to start from scratch. We had to build a new courthouse. We tried to stay open while we were building that courthouse. And ultimately, we got to a point, at least here in YOLO, and I know other places around California, where the courthouse is built. We have a virtual courthouse. Right now, we're holding every possible hearing through remote technology in YOLO County, with the exception of jury trials. And that'll be a challenge for us, and we'll start them shortly. But every hearing in civil, family, juvenile, criminal is being heard through remote technology. What's a virtual courthouse? A virtual courthouse for us is where every judge has the capacity to use video technology to call a case and to hear a case, where every lawyer is going to appear in a virtual courtroom, present their case, present their argument, present their witnesses and evidence. And it's all about providing fair and timely justice in a safe way. That was the mission statement we came up with the first week: fair and timely justice in a safe way, and to do that using the virtual courthouse. And of course, we were just following our leaders. I mean, the governor said the courts were essential and they were an exception to the shelter in place. The Chief Justice issued emergency rules for the state courts. Emergency Rule 3 in particular promotes video hearings in all calendars. And then there are respective emergency rules, like Emergency Rule 5 in criminal matters and 6 and 7 in the respective juvenile. And so that's what's driving us, the need to stay open, as the governor indicated, we're essential, and the chief's directive to give us that tool to do it by remote hearings. And I know at the federal level that the district courts have made every effort to stay open and to utilize virtual technology through their general orders in the respective district courts here in California. So where is here the virtual courthouse? How do you do it? Let's talk about that today. What are the do's and don'ts, the advantages, disadvantages, and so forth. The last thing I would say on this, and I know we'll touch on it a little bit more, but by way of introduction, is my view of it is that California is the most prosperous, most successful, most dynamic, most diverse community in the entire world. And we need to provide fair and timely justice in a safe way. And if anyone can pull it off, it's California. And I just put that challenge out to all the judges and all the lawyers and everyone in our legal community that we have to put this right. Virtually all the technology we're using was made and created by California engineers and California designers. And we're proud of that. They say, get the economy going, open it up. Well, you have to have courts open. You have to have justice. You have to move civil cases along in order to have an economy. And it really helps to have those family courts open for the emotional health of our families. And so that's what's on my mind is we put the virtual courthouse together. And that's where we're here in a very brief thumbnail as to how we got here, Mary.
Yeah, thank you. Challenge accepted. Anything to add to that, Judge Freeman or Justice Grimes?
You know, I certainly the federal courts have experienced the shutdown and the reopening very similarly to the state courts. We have, I think, been very successful at not even needing to stop our civil calendars, but to switch immediately to first to telephonic appearances and then to the video. We have had a harder time starting our criminal cases. We have far fewer, and we've certain than the state courts, and we've certainly kept the arraignments going, but it's I'd say that's been a bigger challenge for us.
Yeah. Justice Grimes?
Well, the California Court of Appeals Second Appellate District has used teleconferencing for our oral arguments since mid-March. And everything changed only yesterday. We introduced video conferencing in the Second Appellate District yesterday with Division 7. They plan to hold 3 days of video conference oral argument. So our court's experience with video conferencing is extremely limited. We're just unfolding this new experiment. But yesterday's arguments with Division 7, which I observed in part, went very, very well. There were a few glitches, but there are glitches in the real live courtroom too. And everyone accommodated and adjusted, and it was very much as if we were all in the real courtroom yesterday.
Kind of moving forward right from that, we've all been thrown into this new reality where the attorneys are addressing the courts from our kitchen tables, our home offices, and sometimes even our bedrooms. And there's lots of potential pitfalls with that. And I'm guided by the observation of Judge Macadam that this is the new virtual courtroom. And we must treat it, you know, the invitation there is to treat it with the same dignity that's required in any brick and mortar courthouse. And so he also, you know, offers us the challenge that we as lawyers have an ethical duty to rise to the challenges that are presented here. So in terms of what have we seen so far in terms of living up to that, again, understanding that we've been thrust into this very quickly, Judge Freeman, what have you seen so far in the federal district court in terms of sort of decorum and presentation?
I've been surprised that the decorum has been, without exception, at the highest level. What I'm finding is that lawyers do step into the virtual courtroom and they are dressed appropriately. They are ready for the argument. It's polished. It's presented well. I noticed that it seems that maybe more attorneys get to participate in the hearing because the travel restrictions are and the cost to clients are no longer there. Sometimes I see some of the senior most attorneys who are in faraway offices participating. Sometimes it's more junior attorneys who might not have gotten to argue in the case. And so that's been really satisfying. We did start with audio only as the second district court did. And it was actually very acceptable. It's nicer to see faces, but I was really impressed by what a good job everyone could do with the audio only. And it's allowed us to retain court reporters, so we are able to make one can get a transcription of the hearings because our court reporters can come right in to the virtual courtroom as well. and they can produce a transcript, which is something I've been really happy about.
And I'll ask both you and Judge Macadam, because you've had some experience with the video, is there anything that you would make comments on in terms of the backgrounds that you're seeing, you know, the attorneys use on Zoom? Is there something that you would consider appropriate or inappropriate or distracting, or do you have any kind of comments for the practitioners on the Zoom backgrounds? And
Well,
I'll start
it's
with you.
interesting. So, you know, even in preparing for this hearing, we talked about what background we should put behind us. I have actually enjoyed seeing the location that people are in. Some people are in offices, some are clearly at home. And the only thing that is distracting is if, frankly, I haven't seen it, but if your cat walks across your desk or if your children run in, it's fine. It's life and it happens. But those things clearly would be distracting, and I haven't seen that at all. So that hasn't been an issue for me. But in terms of the background, I know some of our judges have taken pictures of their courtrooms and they put their background as the seal, the federal seal, and the flag. I haven't done that yet, but we certainly wear robes when we are presiding, and try to make it as respectful as we can.
I think the background is important, and I enjoy seeing the various locations and offices. I've had witnesses, just today I had a hearing where the witness was on the cell phone in the car, and you could see the roof of the car and so forth. And it's a reminder of what we're doing. It's a reminder that people are living their lives and yet appearing in court. But I do think the lawyer ought to be very mindful of their background, and the backgrounds that you can put up through the various technologies are good. And I think I would encourage the courts, and we'll be doing this here, to post backgrounds of the courtroom. Our district attorney in Yolo County did that themselves, and so like the judges appear with the background, they have the counsel's table, and you know, when you first see it, you chuckle, but you know what? It wears well. Every day when I see those lawyers appear like that, it leaves an impact that they're dressed ready for the virtual courtroom. We're doing everything we can to emulate the courthouse experience, and I think that video is really important. And we made that transition from the telephone, and now we're all moving into the video. And the power of the video is amazing, to be able to actually see the lawyers when they make their arguments. It is different, and it does have an impact, and it is more close to the actual courtroom experience. So that's what I would say on backgrounds. Mary, can I comment a little bit more about other things I've seen?
Of course, please do.
Yeah. So I was thinking about it from the perspective of the various people, and one of my colleagues who has the juvenile dependency, who has kids regularly in court, told me just yesterday, that Zoom has changed everything for these kids, that how nervous those kids were coming to court and having to deal with parents that they were trying to reunify with that were not in a right space mentally, or appearing on a 602 situation or whatnot. The kids are very nervous in those calendars. And she's been able to take testimony from children using Zoom, and it's emotionally, the connection between the judge and the person is actually even better than you get from that very nervous setting of the courtroom for the children. And that's an observation I hadn't thought of yet, and I just wanted to share that with everyone. So the other thing is just in speaking about the video and that connection, it's just really effective for everyone to actually be able to see the face of the lawyers that are presenting and to see them in that professional setting with a good sound, a good hardwire internet connection, and everything working well. Like I think we're presenting right now. Cross your fingers that something doesn't happen. But I think that the parents of cases in family and juvenile, our experience is that they've been very pleased with the Zoom court. Pro per litigants are appearing and are very happy. And again, they're in their cars or at home. And they have been we were concerned about access to justice for pro pers. And the response has been overwhelmingly positive. We've been able to hook them up with interpreters when that's necessary. We have criminal defendants that are very positive about this. Not always the public defenders, but the criminal defendants who remain at the jail and appear by video have liked that and like it, and their families can follow along and so forth. So overall, it's been very positive. And I agree with Judge Freeman, who remarked about attorneys not having to travel on the freeway for an hour to get to a hearing, or coming from even farther distances, and are able to really give that argument or present witnesses. So what we've seen so far, there are a lot of technical glitches. We have to restart Zoom occasionally. There are sound problems. Occasionally a witness has trouble connecting, that's for sure. But overwhelmingly and surprisingly to me, it's been a really positive experience.
Yeah, that's great. And that's just leads us right into our next topic. It is a whole new world, and we're still seeing the repercussions of that. And, you know, the remote hearings have a quite significant impact on both public access to hearings and access to justice issues. Regarding the former, I had an opportunity to see my first California Supreme Court argument live this week. And that was really an amazing experience, you know, as someone who's practiced for some time. But there's many, many different repercussions of this, as I mentioned. Justice Grimes, can you talk to us a little bit about the impact of making the courtroom available remotely?
Sure. I was told by my presiding justice yesterday that now that we have video conferencing available, it will be up to each presiding justice to decide whether that division will use teleconferencing or video conferencing going forward. The Court of Appeal is using the Blue Jeans platform, which is the same platform being used by the California Supreme Court. The court clerk initially mutes everyone who is not speaking, and each justice and lawyer must unmute their device in order to be heard. There is a phone-in option for those without access to Blue Jeans. Up to 200 public viewers may join the arguments. They will not be seen or heard, but the justices and lawyers may see a list of those who are observing the arguments. The arguments are video recorded and also audio recorded, as they have been traditionally. At this time, the court is not able to post the webcast of the oral argument to our website, but we expect to be able to do so later this year. Obviously, it's too soon to tell, but I think video conferencing is here to stay on the Court of Appeal. Until recently, very recently, I had expected everyone would clamor to return to the real courtroom as soon as possible. But there is a lot to be said, as the other judges have commented, for avoiding the commute, the security screening, and all the other hassles of getting into downtown LA and elsewhere. I think our court will be able to expand our public access so that arguments may be seen and heard by many more people than our courtroom can hold. Like Judge Macadam commented, I observed an argument yesterday before Division 7 in which one of the litigants was self-represented, and it went very, very well. There's something about that seems to sort of level the playing field for the self-represented litigant when we're all on the Zoom platform. Someday I think we may look back and wonder why it took a pandemic to get us to transition to video conferencing.
So, Mary, I'm just going to offer a little side note on this. I couldn't be happier that we can continue the operation of the court and the resolution of disputes on a timely manner. It's so important. I am not in favor of giving up the physical courtroom. And I think we lose a lot as a branch of government and and for the rule of law to just elect to have this become something that you do from home is never, in my view, going to take on the gravitas of the courthouse and the seriousness that comes with walking into a court of law. So I think that there are aspects of this that I hope are here to stay. I would love, as a member of the public, to be able to watch the California Supreme Court in argument. And I would love it if the public could could come to my courtroom by video. But in terms of litigants and argument and the seriousness of what we do, I hope this is not something that's here to stay.
It's going to be interesting to see what happens going forward as we continue to, move out of the pandemic restrictions.
Also, see, glitch number one. It bears noting, it's a big difference between trial court proceedings and court of appeal proceedings. If I were a trial court judge, I would be anxious to do everything in the real courtroom too. And of course, when we are permitted to return to the courtroom, if and when that time comes, I will be happy to go back. But if we were to decide to remain with video conferencing, the limited experience Division 7 had yesterday suggests to me that the same gravitas and attention is there as in the real courtroom. And there is something about it that seems somehow, maybe it's being able to see people in their homes and their offices. It seems even more intimate, and it seems easier for the judges and the lawyers to interact, notwithstanding the glitches of talking over one another.
Right. I mean, that's been my experience in the limited weeks that we've had it. But we were talking about public access, and I wanted to mention one of the things that we're doing here, and that is that all of our courtrooms, except juvenile and family, are being live streamed by YouTube. So the video feed is being live streamed, and that is absolutely remarkable. I mean, you talk about public access. So the victims of crime can watch a preliminary hearing. Family members of the defendant who's maybe in jail can watch without having to travel afar or come to the courthouse. Neighbors in a property dispute. The media, I know personally that our media watch the live stream on a regular basis, and it enables them to get more timely news to the community and not have to spend time driving to the courthouse. Obviously, what comes with that are the bloggers, and they follow it as well. And as they have every right to do so. We have law students following it, high school students following it. And my view of it is I'm a public servant in a public forum doing public work. And if somebody wants to see that, have at it. And so I'm very happy that we're able to live stream. It's one of the things I hope that that we keep after, but we'll discuss that with our justice partners in our communities. The judges don't make that. We take input from everyone and determine what's right and what's best for our community. And there are problems. For example, we had a Penal Code Section 288 sex abuse preliminary hearing, and it was very graphic. Well, YouTube shut us down. Okay, rightfully so, right? And if you have a murder case with graphic pictures and so forth, you can't live stream these things. So, there are things we have to be careful about and things that we have to do. We have a rule that you can't record the live stream. Some question how enforceable that is. Well, time will tell. But the other thing that we do with our live stream is once the live hearing is over with, it's gone off YouTube. So it's not there. Unlike a court of appeal where you might want to preserve that for other people, we've taken it down. So we've given that same courthouse experience. If you want to sit in the gallery, you can do that. But once the door is over, you don't have a memory of it. We didn't allow you to record it. You don't get to keep putting that proceeding on the internet and make somebody look bad or make somebody look good or whatever it may be. So there are going to be problems with live streaming for sure. But it does provide an amazing amount of access, and we really haven't gotten any negative feedback yet. But we're still learning; it's still early. But anyway, that's my view of public access.
Yeah, a lot of repercussions. One of the things that there is some concern that remote hearings will result in fewer opportunities for oral argument. And while we've heard from Judge Freeman that it's really business as usual in the district court, do we have a slide for this one, Michelle? We have seen some impact in the federal appellate court. And what we know that in all, 35 of the 54 cases originally scheduled during the court's April session were submitted on the briefs. And oral argument was only held in 19 cases. And so we compare that, and if we look at the civil cases, 30% of the time, the court submitted calendared civil cases on the briefs and before COVID, and then 67 submitted on the briefs since COVID-19. So then we look at the stats for the criminal cases. So, you know, we are seeing that there is some a lessening of oral argument being presented. Is there any concern from the bench that that there is limited opportunity or a more limited opportunity for oral argument in some venues?
You know, I think some judges are on the federal bench are hearing less now. My guess is they will change as this goes on and we become more comfortable. I have oral argument and everything, and I still do. So I've been able to keep it business as usual.
Well, and I think we would be remiss if we didn't look at the United States Supreme Court, you know, as they took their first dive into the uncharted waters of the teleconference hearings. And there's a little blurb that we have here that over the course of the 10 hearings in the month of May, the justices braved their way through mute button mishaps, an unexpected toilet flush, and the live tweeting of thousands of attorneys, journalists, and court watchers who had tuned in to the first ever remote oral argument in the court's 230-year history. So they have come out unscathed, and so we're heartened by that. And I will say too that, you know, it's serious business that we're talking about here, and really, you know, this idea of presenting and perceiving this as a virtual courtroom is important. But despite our best intentions, you know, real life does happen. And it was perhaps best illustrated by Senator Duckworth's recent post. And Michelle has kindly put it up here for you. And for those of you who may not be able to see it, she says, "So today I didn't realize I was off mute and told the Democratic caucus, including a couple of recent presidential candidates, that Mommy is working, honey. Please go potty and wash your hands, and then Mommy will come downstairs." And then she concludes by saying, "How's your working from home going?" And so, you know, there will be moments, and to quote Justice Grimes, you know, just roll with whatever happens and maintain professionality when that happens, because it will happen. So, you know, we want to get to the very interesting topic of socially distanced trials. And before I hand this off to Michelle, I will say we're getting a lot of questions. Continue to put them into the chat. We're not going to be able to get to all of them for sure, but I will be looking through them and trying to get through some. We'll leave time at the end. But with that being said, this idea of socially distanced trials is really on everybody's mind. And so Michelle Galloway will pick it up and talk with us a little bit about that whole scenario.
Yeah, so as a trial lawyer, for me, while remote hearings, I can conceptualize thinking about how to have the participation of a jury and all that entails is something that many of us are watching who have trials scheduled this year. And I know courts are particularly interested in that as well. So I'm going to just sort of start by throwing out voir dire. Any thoughts about how that's going to look in a virtual courtroom?
So on the federal bench, we've begun to devote time to this in trying to determine how much of the voir dire can be done remotely. And so certainly for all jury selection, we select jurors in layers. The first layer being the mere qualification. Our jury offices do that. You have to be a citizen, you have to be 18, you have to live in the district, you can't be a police officer if it's a criminal case. There's a few basics that they take care of. That's always been done remotely. We're talking about also doing remotely some special questions to jurors that would be COVID specific to find out if people have risk factors that mean they simply can't come to the courthouse, and that would be done remotely. We're also looking at the next layer of the normal hardship and the basic identifying information, your name, what kind of work you do, those things, to get all of that done remotely through we're even thinking about using a Survey Monkey kind of questionnaire so that we can get the basic information, not case specific. Then what we're looking at is when we finally hone down on the jury panel of bringing jurors in small groups. So we have literally measured out every courthouse, every courtroom in the courthouse, and determined that in most courtrooms, you can only have 10 people in the courtroom at a time. And so we're looking at which of our staff members can be remote, such as our court reporters. They can work remotely. We're looking at our jury boxes. We can't fill a jury box because people would be too close. So we're looking at putting 4 or 5 people in the jury box, the remainder of the jurors in the audience. We're looking at spreading people around the courtroom so that they're not near each other and having extra staff to come in and clean after every witness. We're looking at making ourselves like your local grocery store with plexiglass in front of everyone to the extent we can. But the bottom line is we're slowly trying to come up with a way to have a jury trial. I will honestly tell you we are not there yet because we want to be certain that we're not endangering people. And frankly, we have a concern that our members of the community simply won't come to court. We've always had a fail rate on people answering their summons, and we expect that's going to go up. So we're going to have some real challenges. I would say, the last thing I'll say is we are not considering having the jury sit remotely and participate as jurors in different locations. That doesn't seem reasonable at this stage.
Right. I think that's the same in the state court. No, we are going to have jury trials live. And while I have great enthusiasm for the virtual courthouse, it underscores for me that the courthouse should be reserved when we have these safety issues, but also even when you don't have a safety, the courthouse is reserved for the hardest, most difficult cases in our society. And the cases that you can get plea bargains on, you can reach settlement agreements, you can agree on discovery motions, you can mediate family disputes. The lawyer should be working outside of the courthouse to get all of that work done and reserve the resources of the courthouse and the staff and the judge's time for those very difficult issues. And at the top of the food chain is the criminal jury trial, the criminal felony jury trial, and civil trials fall right behind that. And they're very important, and they have to be done live. In civil, they can stipulate and so forth. So I think we're really focused on a criminal jury trial. It has to be live. There has to be social distancing during voir dire, and I echo what Judge Freeman said about voir dire. We're going to use Zoom and telephone for the hardships, including COVID-19 hardships and general hardships. And then the group that comes in for voir dire will bring one group into the courtroom and keep another group in other rooms, spread out social distance, and they'll be live streamed so they can follow along so the judge doesn't have to repeat everything that's going on. Our courtroom holds a little bit more. We can get at least 14 jurors in there with 6 seats for other public, and then plus the attorneys and so forth. So we got a little bit more flexibility there. But yeah, we're going to have spit guards and face coverings, more sanitizing, and it's going to be very slow. It's going to be slow because you got to get people up elevators in a socially distanced, responsible way. You got to get them through the courthouse, through security. You've got just a lot of great challenges. Jury deliberations we're going to do in the courtroom with guidance to the jury. We're not going to stick them in a small room, no chance. And but what we were able to do, and I think the state courts, for those of you practicing in state court, you have a little bit more of advantage than the federals because you have a smaller geographic region and a more cohesive unit. So we were able to give a press release, talk to the media, tell our community, hey, you're going to get a jury summons, and here's what we're doing to keep you safe, and describe and remind that jury service is both a duty and a right. And so if someone over 65 wants to come in, we're not discriminating against them. They're going to make that judgment call because this is essential work and so forth. So there's a lot of tricky things that go in to doing a live jury trial. We have set July 6th for our first date, and our summons have gone out for July 6th. I think there are state courts, some of you practicing, it's starting sooner than that, because the deadline came about. The Chief Justice extension for jury trials only ran through June 15th. So there's certainly going to be jury trials in this state before we start July 6th. So those are a few of the observations that I have about what we're doing.
What about, so you're bringing the jurors back in the courtroom, curious about the witnesses, because often witnesses are coming from a substantial distance, right? It's not the drive to the local courthouse or public transportation. They might be required to fly across the country or even international borders. So can you tell us, like, maybe we'll start with Judge Freeman, sort of what is the thought about witnesses and that idea that you're supposed to be able to confront them? And what do you think about that in a virtual courtroom?
So that's been on my mind. I have a patent trial that I've continued twice now, hoping that we'd reopen. One of the parties' major witnesses come from out of the country. And so they were looking at a 14-day shelter in place just to come into the US, which is virtually impossible for someone in a company to give that kind of time. I think we can work it out for the civil trials, because I think jurors are used to seeing videotape depositions when witnesses are not available. And I think that with Zoom, it will actually be live testimony. So I think that will work in civil trials. The problem in criminal trials is that twofold. I think that there are confrontation clause problems with remote witnesses, but I think there are equal confrontation clause problems with witnesses testifying with face masks on, and we are requiring face masks in our courtrooms. And Justice Grimes will have the opportunity to rule on some of these things. We're just going to we roll up our sleeves and get the work done, and then we find out what we did wrong later. But I think there are real problems in criminal trials. There's a real problem with the defendant sitting in a courtroom with a face mask on. We do everything we can not to help a defendant not look like a criminal when he or she's sitting in the courtroom. And if you put a face mask on somebody, that's going to really be a problem. But the defendant has the right to confront witnesses, and the jury has to judge credibility. So those are going to be serious and real problems that we're facing.
Right, and I couldn't agree more with everything that Judge Freeman said. And so all of those indicators that I said about the advantages of the virtual courthouse, they run up against the wall when you're going to do an important criminal trial. So you got to take the face mask off. It's about judging credibility. The witnesses, and again, that's one of the advantages to having this format, because I can see everybody and really well. And in fact, quite honestly, as a judicial officer, I can see you better now than I can looking at your profile in court sometimes. And but anyway, the witnesses will be, to the extent possible and not stipulated otherwise, they're going to be live in the courthouse. We're going to keep doing that. That's critical to due process and fundamental. So I got to show you what our judges are required to wear face masks. So yes, that's right. You can wear a face mask like that. Okay. So, maybe the lawyers have to wear that. So this is what I'm wearing though. Okay. So I got a face covering like this. Now, if there's no glare, you can kind of see my face, but I'm not sure this is the solution either. But I have staff that's close to me, my clerk and my court reporter in my courtroom. Some of our judges call their cases from home. I happen to do it from my courtroom, and I wear this. And when you first see it, I think it looks a little goofy. I've been doing it for a couple weeks now, and it's like Matthew McConaughey says, "Hey, if you're wearing face covering, you're doing something for me." So I'm trying to help everyone else out, and that's why I do it for my staff. But it is a little unusual. I do admit that. So yeah, we're working through all those challenges with respect to jury trials. I want the witnesses in court. I want them live. Without making any broad ruling, I do believe that we're faced with confrontation clause issues, and why not try to do the live jury trial as best we can.
So as an attorney, I of course am compelled to ask, there's the famous when you go to the sidebar and you get to whisper with the judge and the other lawyer. And so, and sometimes, those can get somewhat heated if people don't maintain their professionalism. one of the things I worry about in the virtual courtroom, so like take a hearing, if I want to consult with my client, do I need to worry about privilege in my breakout room, or that I might get returned from my virtual breakout room to the courtroom right as I'm saying something critical to my client? What are your thoughts about that and sort of both the hearing context and the trial context about what lawyers should be mindful of?
Well, those are really serious problems. The breakout room is only as good as you think that technology is, but frankly, whispering to your client in the courtroom is only as good as the bad or good hearing of people around you. So I don't know that there's going to be that much difference there. But I do think that the sophistication of the technology is improving and giving you that space. But there's also the opportunity in a trial to simply say to the judge, can we take a break? And for you to pick up your telephone and call somebody if you're all remote. You can use a different device. And I actually think that if I was doing a trial, that everyone, and if it's all lawyers, will be able to do it. It's that we may have 2 devices running, so that we can immediately switch over to another device to have that conversation. You know, how many yellow sticky notes have come up to you when you're examining a witness, but all you need is a screen in front of you that's going to have a chat box open to see those things. Or, like most lawyers, don't bother me, I've got this covered, they don't want to read them. So I actually think that there are ways of doing this that we don't have to rely on the technology being designed to help our confidentiality by simply getting off one device and getting on to another.
Yeah, I agree. And then I got concerned about the ethics. You know, you've got a witness who's appearing remotely, and they've got their cell phone right there, and somebody can be texting them, oh, you need to say this and so forth, and nobody knows anything about it. And that concerns me. Maybe because it's new, but I just had the same reaction that Justice Grimes has. And the professionalism for me, and Judge Freeman, you mentioned this too, the professionalism for me has been off the charts. I mean, people don't speak over each other. They're more succinct. They don't ramble. They don't raise their voice. I mean, it's been really impressive. And maybe because it's new, I hope that stays. But there are so many ethical issues for you lawyers, okay? And you have to rise to the occasion. We have to start teaching students, teaching the associates in your office, if you're a sole practitioner, being that person that lives by the rules of ethics, because there are ways that this can get a little crazy. And those breakout rooms are a concern, and I think that Judge Freeman's on it. You want to be able to communicate in an alternate digital way with your client. But everything has to be ethical. Everything has to be ethical, and you can't influence testimony, for example. But so far, Michelle, the breakout rooms, when they first started, you know, we've been at this for, you know, many weeks now. When it first started, there were all kinds of problems. People weren't pressing the right button, and we could hear conversations. People forgot to mute themselves when they were certain places and so forth. It was a mess for 2 or 3 weeks. And it cleaned up substantially, and the breakout rooms are working. The technology is not that hard, and it comes back to where we started, and Mary had mentioned it, with ethics. This is the courthouse, folks. This is it, and the technology is available, and we all have to know how to open the door, if you will, go through security and get into the courtroom. So anyway, I think it can work, and the breakout rooms are really good for settlement conferences, and they are working.
Okay. And Justice Grimes, we've heard several allusions to it already, but the appellate court gets to watch this all happening. You get the chance to hear what your colleagues are thinking through. I know considerations have been the emergency orders, both from, you know, Governor Newsom, but also emergency positions that the trial courts are taking. And then the appellate court also coming online. Do you have any thoughts about sort of what that's going to look like in terms of what the appellate courts are preparing for in terms of people challenging some of these approaches to hearings and trial?
we're at the very beginning on that. I know very little. I will share with you the little I do know. Los Angeles Superior Court Presiding Judge Kevin Brazil has a working group to develop ideas for socially distanced courtroom proceedings. And an appellate lawyer I know with Horvitz and Levy gave me a copy of a letter that he sent to Paul Kiesel, who is collecting comments for Judge Brazil. And his letter contains some suggestions, and I will mention them to you here. These are the ones that immediately struck me as having a considerable merit, although I have no idea what Judge Brazil and the Superior Court will decide to implement. The overarching thing to remember is that a complete record of proceedings in the trial court is critical to demonstrate prejudicial error on appeal. And that is not going to change because of the pandemic. Remote advocacy requires new protocols to preserve the record. One example that Horvitz and Levy suggested was that the trial court might decide to keep electronic folders, for example, in Dropbox, separate folders for exhibits to which there is no objection, exhibits to which a party objects, excluded exhibits, exhibits that have been admitted. And there might be also separate folders for jury instructions, those that are agreed upon, instructions to which there is an objection made, the instructions the court rejects, and the instructions the court gives. Whenever possible, counsel should prepare their own appendices of the record for appeal rather than requesting a clerk's transcript. And it would be good if appellate counsel could serve their briefs on the Superior Court electronically rather than having to mail a physical service copy. In general, parties should not be asked to waive notice of any rulings, particularly evidentiary rulings, either pre-trial or post-trial, because we need a record of everything that happened. So, and on the comment, Judge Freeman's comment about the courts of appeal passing on whether the trial courts have developed adequate protections to litigants, I think it will be very helpful for appellate courts if the trial judges make extensive records, at least particularly initially, or at least it's somehow advise the courts of appeal, perhaps even invite input from the courts of appeal about the protocols that you intend to implement. Or if not us, forget us, just consult. Be sure you have appellate lawyers available to provide input. But the more explanation that is provided in the record as to what reasons exist for the various steps you've taken to create socially distanced trials, the better the Court of Appeal will be informed to determine whether there has been any prejudicial error.
Well, I think that is, to me, that's a very important point about making that record, because there is the temptation to think, because the video platform that's being used is recording, that somehow that's actually capturing all the information that the appellate court would need, or that that's part of the appellate record. And so I do think that that's a really important tip for the trial lawyers on this call and listening remotely to think about, which is you may need to pay even more attention than an excellent lawyer would to making a comprehensive record for that appeal.
And make a, lawyers may have to make more comments than they ordinarily would. For example, if a witness is, or the lawyer thinks the witness may be using some sort of prompt, inquire, Mr. Witness, what do you have I see you looking off screen. Do you have a video, do you have a telephone in your hand? Are you communicating with someone? Or otherwise making a record about behaviors that you observe that might have an impact on a witness or on the jury, and otherwise would be lost if if the comment was not made on the record.
I was actually able to find one published case that involved a trial court proceeding where the witness on the stand, during a sidebar, the witness on the stand was texting the corporate representative, and they were having communications about the testimony and what was happening. So it is certainly, you know, as Judge Macadam said, we have ethical obligations. Sometimes, you know, clients and witnesses don't always follow that guidance, or they're not given that guidance, and so that heightened sensitivity, I think, is going to be with us for a while in this format. So what I would like to do is sort of skip a little bit, because it's been a great discussion. I want to focus on one other thing that comes up a lot in both hearings, but also at trial, which is sort of the presentation of either documentary evidence or demonstratives. And one of the things that struck me, so maybe I'll start with Judge Freeman and Judge Macadam. I've listened to a number of seminars from other states about, you know, where other judges have been talking, and they lamented that attorneys were not using documents and demonstratives in hearings. So not using the share feature like I've used during your presentations to share even a few slides that would help walk the court through an argument or presentation. So can you tell us a little bit about what you've seen or what you'd like to see about the use of exhibits during this time of virtual hearings?
So I agree with that. I now in 10 weeks have not had a single exhibit put on the screen during an argument. And I was used to having incredibly professionally prepared slides and a slide deck to give to me at the end of the hearing that was very helpful. So I don't know whether the lawyers are unaware that we can manage that, or whether we need to put out the word that we want it. But I really think lawyers are hurting themselves by not using the kind of demonstratives with argument on motions or to show key exhibits. I'm fumbling with my papers because I'm still a paper person, but if I don't have paper, I can't manage it on my computer. That's just not an easy way to get to exhibits in the record. So I think it's a big miss on the lawyer's part that have appeared before me.
Right, I agree. And I covered a small claims case the other day, and both sides shared screen with me. And we had required that they submit their exhibits in advance. So I had the hard copy in front of me, and each of them shared screen. It was a contractor dispute regarding the installation of an elevator. And they were able to present the diagrams and pictures of the work and the bids and the quotes and other evidence. Probably saw 10 to 15 pieces of evidence. 2 laypersons, magnificent job. And I mean, it's amazing to me. Again, we're back in California. I mean, this is happening all throughout the country, but there are a lot of Californians know high tech, right? So they didn't have any trouble with it. What we have seen, I mean, the state court has an advantage with just this high volume of evidentiary hearings going all the time. So in our criminal courts, we've had the police body cam presented in evidence at preliminary hearings, the 911 call, that'd be audio, pictures of a domestic violence victim presented on the screen. So these are prelims where the prosecutor's putting evidence on through a police officer. And I gotta tell, it's really compelling to see it on your screen. Of course, we have a screen in our courtrooms too, but there's something about that screen right in front of you, and you're watching the police body cam, which obviously is a timely issue right now. And it's very compelling. And yes, the attorneys need to know how to get the exhibits in. For our court, you send the exhibits a week in advance or as soon as you can. Preliminary hearing, obviously shorter time frame, but you send them in. Those will get entered into evidence when the judge makes the ruling, and then you share the screen. Have at it. And I just think I think it's essential. Again, we all have to step on the accelerator and learn how to do this.
I know Mary has a number of questions that have come in, so I'm going to let her have a few minutes to ask some of those from our audience before we ask for your final thoughts.
Okay.
So I'm going to try to, and thank you, Michelle. I'm going to try and combine some of these because we seem to be getting a lot of questions on this particular topic. So let me combine a couple of these. This one was specifically directed to Judge Freeman. What differences have you noticed in terms of oral argument? And do you have any suggestions for counsel on things to do differently because they're on video? I'm going to combine it with this question, which goes to all of our judges. Can the panelists share some tips, i.e. do's and don'ts, on appearing virtually? For example, lighting, use of hands, standing instead of sitting. And we've got other questions about this idea, this notion of whether the court during oral argument has a preference for whether the attorney stands or sits. So I've thrown a lot out there, and I'll just take it from my screen from left to right. We'll start with Judge Freeman and go to Judge Macadam and then to Justice Grimes.
All right. So in oral argument, we talk about it being a virtual courtroom. I have not had a single attorney stand, and I actually think that would be quite awkward.
Yeah.
But in terms of making it effective, there's one big difference that I've noted. I can't have a dialogue with the attorney as I normally would, because it's too hard to read the body language. When I want to interrupt, I have to talk over the lawyer. So we've become a little more stilted. I give my opening comments, I hear from the moving party, I move on to the response, and then I may interject some other comments. But I've lost that conversational aspect of my oral argument, and that's a technology issue. I've even taken to saying to them, I may wave my hand to let you know I want you to pause, because my court reporter can't hear two people talking. In terms of other things, lighting is an interesting thing. You need to make sure that you don't have a very bright window behind you, because that will darken your face. And if you have a light that you can put behind your computer screen to put light on your face, that helps. Right now, I mean, just looking at myself, I'm a little bit in the dark. Hopefully it's not too distracting, but I don't have that light on my face that would be helpful. But the light behind you it makes the camera cut down on the lighting on you, because it's got a balance, and that's a really important thing. Close the shade, move the screen, whatever it takes, that really helps. You need, the other thing that I found distracting, I took a plea from a defendant the other day, and he wasn't doing it to do it on purpose, but he was too far from his camera, and I couldn't really see his face the way I wanted him to. You need to be close to your camera, wherever it is. And when you have these tiles, you have to figure out how to look directly into your screen. So on my iPad that I'm using, my camera is over on the right. And if your tile is on the left, when I'm talking to you, I look like I'm turning away from you. And I'm trying to train myself, if I want to see everybody on the tiles, to look at my camera. So you need to make notes around your computer screen. And remember, I can't see what's behind your computer screen. So if you want to put a big arrow that says, look here, you can do that, because I won't know it's there.
Thank you. Thank you, Judge Freeman.
I can't believe I'm going to give lighting advice, but just briefly, I learned after like 3 or 4 weeks of being in the dark that the key is to actually have the window behind your computer screen. So I'm looking out at beautiful woodland right now above the tree line, and it's a great view for me. But in any event, that's why I get the light here, and so that's just one tip. But I talked to, for me, I'm in my 50s. I got kids that are high-tech kids in their 20s. I just started asking my kids. I said, what am I supposed to do? And fortunately, I got 2 kids that were giving me high-tech advice.
Can you get their numbers?
Yeah. Fox Corporation.
Justice Grimes.
All right, so I have some ideas too. First, it's important to reduce the ambient noise as much as possible in and around the room you're using. You want to avoid having other people talking, street sounds, televisions in the next room, household appliances such as washers and dryers. And as Judge Freeman said, make sure you are as near to your desk phone or computer microphone as is comfortable, because this will help intelligibility. Even with good broadband connections, there is a little lag between when someone speaks and when everyone hears, not always, but sometimes. So you might want to wait a beat before jumping in to speak or answer a question. You can't assume that everyone's connection is good or consistent, so it is better to talk more slowly and enunciate more clearly. As Judge Freeman said, that's somewhat stilted. It's not the way we talk when we're together interrupting. We can readily interrupt one another and not feel interrupted, but it feels very interrupted when the Zoom connection gets confusing. You go, no, you go, no, it's your turn type thing. Also, and I think this is a point Judge Macadam made, when using video conferencing, remember you can see everyone's faces more clearly and distinctly on the screen than in court. Lawyers should avoid inappropriate facial reactions, such as eye rolls and smirks, but justices also should avoid appearing inattentive or less engaged than they would be if counsel were actually standing before them. And other things are rather obvious, like if you need to drink water during a hearing, as I frequently do, it's probably better to have it in a glass than to drink straight from a bottle. It comes off funny. So there are things that you can think about to preserve the gravitas of the proceedings.
Thank you. I will throw one more question into that mix there. And I've gotten several questions on whether there is a preference or about the attorneys wearing headphones during the remote hearings and whether there's any reaction from the judges. So if anybody has any strong feelings about that one way or another, I'd invite you to comment on that.
My strong feeling is wear the headphones, yes, if it improves the quality of your presentation and it gets rid of outside sounds, you're able to hear better. I'm not troubled at all. We're doing this remotely and those headphones can really help.
All right, it looks like Judge Freeman and Justice Grimes are in agreement with that. Okay, a little more weighty question. How do the courts deal with the challenge or the opportunity in working with deaf or hard of hearing clients that may require interpreters and ensuring that the setup takes these things into consideration? Have we dealt with these issues at all yet? And I'll do it the opposite order. I'll start with Justice Grimes, although I know you've just been doing the audio hearing so far.
Well, I don't know how we'll deal with that, but I know that we will deal with that because even when we were appearing live in the courtroom, there were people with disabilities who required accommodations of various sorts. So it's important that the lawyer or self-represented litigant who needs accommodation communicates that need as soon as possible to our court clerks. And our court clerks will work with each person to be sure that they are given a level field on which to make their presentation. It's a very important question to deal with. I am not aware that we have yet had a person with disabilities make a request for accommodation related to teleconferencing or video conferencing, but certainly we've had many other types of requests for accommodations for people who found it difficult to appear in court. So there are just new challenges and we must and we will respond to them.
Right. I think that goes to a couple of points we made earlier so that's what the courthouse is for, right? So if that person can't be accommodated through the virtual courthouse, then that hearing has to be held in the courthouse where we can accommodate the litigant. And that's just critical. I mean, we were talking earlier, we're not trying to eliminate the footprint at the courthouse. We're trying to reduce the footprint at the courthouse. And so it's important if there's some reason, some good cause reason where that virtual courthouse isn't going to work, then we're going to have a live hearing. And we identified most prominently jury trials. But I can imagine if we can't figure out the technology to accommodate a disabled person, then we're going to have a live hearing for that person.
That makes good sense.
Yeah, absolutely.
All right, let me go to the next question. Does a remote evidentiary hearing in the trial court require waivers in view of the party's rights to be present and confront the witness? And I'll start with you, Judge Macadam.
Okay, so that's a loaded question. It really depends on what the subject matter of the case is. So in the criminal courts in state, it'll be governed by 977, and the Chief Justice has modified 977 through her emergency powers. So I think that's the lawyers really need to kind of brief that issue. Whether those same rights apply in a family custody hearing or in a juvenile 602 hearing or in a civil case is really a different question, because there's no statutory authority where the person has a right to an in-person hearing. It's only in the state law, it's only that 977 penal code authority. So anyway, I would encourage all the lawyers to kind of brief that issue. And if you want to claim you have a right to a live hearing, that the virtual courthouse is not a lawful proceeding, brief it, let us know.
Any other thoughts on that?
Well, we have really worked hard at making the distinction between cases where the defendant has the absolute right to be present in the courtroom versus the discretionary right, so that we could keep some criminal proceedings going forward. Certainly with pleas and sentences, the defendant has to be there. And we've actually decided that pleas and sentences generally, if they go forward, they require waivers. We do as many that are video as possible with a video hookup from the jail. And with trials, no one is suggesting trials in any way in criminal trials be done remotely.
Thank you. Let me go to another question. This is again directed to the trial courts. The pandemic has given rise to a greater focus on settlements, mediation, and arbitration being handled remotely. Are the trial courts actively encouraging those procedures? And I think I'll start with that one to Judge Macadam.
The answer is yes. Yes. Well, we have time, don't we? Because in my county, for example, we're not going to do civil jury trials until October. Okay. So we have all this additional bandwidth right now for the litigants, and let's tee up settlement conferences. And I think this would be, I think the Zoom format works. We have done settlement conferences, and we talked about the breakout room earlier. And there is some intimacy for Zoom. Also, it's the travel issue. It's much easier on Zoom to bring all these parties in from all around the state or even the country. So settlement conferences are encouraged. The Zoom format seems to be a good format for it, and we have time for it. So all that's good.
And we are certainly encouraging that as well. And for us, generally, our magistrate judges conduct the settlement conferences. And so they are continuing full strength and actually being very successful with it.
That's great to hear. Let me try to put in one more question. It's just, time goes by so fast in these things, it's amazing. Are there any things that you are seeing that you would consider disrespectful that perhaps would not be interpreted that way if the hearing was live? And I will start with Judge Freeman.
You know, I actually haven't seen anything disrespectful. I've seen some fumbling, but it's just a technology issue of people getting used to it, but it's clearly not intentional. So no, I have to say, I think the attorneys have done a remarkable job at stepping up into this new way of doing things.
Good to hear. Judge Macadam, any observations on that?
Yeah, that's as we've said, that's been the experience. Disrespect. Maybe the only problem is multiple people present in the room. You know, so if you're a lawyer, for example, you know, you really want to be in the room by yourself. And when you have witnesses that are going to testify, which I'm doing evidentiary hearings every day with witnesses. It's nice if they're in a room by themselves rather than having other people sitting with them. And so I think that's probably the number one thing, is that it would be nice when someone appears on Zoom that they're sitting by themselves. Yeah.
I can add one thing. I agree with the other judges that it seems to me, whether it's teleconferencing or video conferencing, that everyone is doing their very best to observe courtesies, professional courtesies, in order to enable what is a challenging remote courtroom. One thing that I will point out, and I do not think it was intended to be disrespectful, but at our last teleconferencing argument, someone apparently put us on hold, and so we heard music. And of course, since the person had put us on hold, he or she couldn't hear us saying, "Will you please turn off the music?" So we had to hang up the Zoom meeting and call back in again. It was the last matter on calendar, and only 8 people had to rejoin the meeting, so it wasn't a big deal. But do think about, well, first, don't put us on, don't ever use the hold button, but think about anything that you might be inclined to do. Think it through about what impact it might have.
Thank you.
Judge
Wise
Grimes,
observations.
if I can add one point there, Judge Grimes, I noticed with the lawyers, they often have some kind of thing that rings their phone calls through to their screens. And if they're sharing their screen at that moment, everybody can see who's calling them. So just a tip for lawyers out there that, as you said, disable the things that are going to distract you or cause noise or other things. And that's one that I think a lot of people don't think about. That can be, quite embarrassing when all of a sudden it pops up with who's calling you.
Yes, indeed. Well, we're going to stop the question portion of it there. We are running out of time. What I can tell you is that California Lawyers Association has a COVID resource page, as does the litigation section of the California Lawyers Association. And you can reach that page at litigation@calawyers.org. And again, it's litigation@calawyers.org. And there's a good number of materials available there. I want to thank our judges very, very much before we get them back to them and get the final thoughts and the final takeaway. This has been a rich discussion, and I think very helpful for a number of people. This has also been recorded. It will be available for viewing for free on California Lawyers Association webpage and the California Lawyers Association litigation section webpage. So it will be readily available for you. And so what I'll do is I'll just come back in alphabetical order for Judge Freeman, Justice Grimes, and Judge Macadam, and just ask you if you have any final thoughts or takeaways for us today. I mean, this is the beginning for us. We're thinking through the questions. We're all, both the bench and the bar, figuring it out as we go along. And according to you all, doing a pretty decent job of all of it. So that's really reassuring to hear. But, the invitation is to continually up our game and to bring to it the decorum that a virtual courtroom would require. That is the resounding theme that I'm getting here. So Judge Freeman, any final thoughts that you have?
So my final takeaway from all of this is that I think it's critical that the courts partner with the bar to make this experience the most effective for your clients so that they can continue to feel that they've gotten their day in court. So we're doing what we can, but I've made notes on things I've learned just from the other judges today. We can learn so much from the bar, and I know I say this for my court, probably for all judges. We need your input and your creativity and your assessment of what we're doing right and what we're not there on yet. But it is a partnership.
Thank you. Justice Grimes, some final takeaways for us?
Well, chiefly my additional comments simply echo what Judge Freeman just said. Our learning curve is incredibly steep right now. Last week, when we were having a conference to prepare for this webinar, I learned from Mary that Division 7 was holding video conferenced arguments this week. I didn't know that. I told my colleagues on Division 8 that Division 7 was going to be holding teleconferenced arguments, and we asked ourselves, will they have to wear robes? The answer is yes, of course they wore robes, but these were things that we started to think of for the first time last week. So our learning curve is incredibly steep, and therefore it is very, very important that counsel communicate either through bar associations, the litigation section, the Daily Journal, whatever platform you may have, individual letters from you to court leaders. Communicate your feedback, your suggestions, and keep doing so. Because we do listen. It does make a difference. Because of counsel pressure for justices on the courts of appeal to provide tentative opinions, more and more courts are doing so. Because of counsel pressure to publish more opinions on the California Courts of Appeal, we're now publishing more. So if you want to be heard, or if you have either a good idea or a gripe about the remote courtroom, speak up and be heard.
You're saying that to a group that's known to not be so bashful. Judge Macadam, final thoughts for us?
Yeah, I echo the final thoughts of Judge Freeman and Justice Grimes, and it's thank you for inviting me. This has just been wonderful. Of course, the people that are on this call have an advantage because they're the ones interested in this subject. To the other lawyers that aren't on this call that I'm really worried about. But I would just say to my friends here, this is not temporary. Okay, we have to adjust right now, and we have to learn how to handle the virtual courthouse in a professional way. If the pandemic subsides, as we all hope it does, and we can return to life as it was, the virtual courthouse is still, elements of it are still going to be in place because we've learned things. But secondly, another pandemic can hit. For heaven's sakes, we had the protests that have closed courthouses. There has to be a way for the courthouse to be open in this modern era at all times. We cannot close the courthouse. And so what we're learning now and what we're experiencing now is not temporary. Every lawyer should take up the cause, and they should be teaching this in law schools, and the next generation should maximize technology to advance due process and fairness. And so if you're looking at this as when is it going to be over, I think that's the wrong view. It's like, how can we make this better? And what can we learn from it? And what are the core missions? What has to be done in the courthouse? We've had some discussion about that. So those are my final remarks.
Thank you. Thank you so very much for your time this afternoon. We're just deeply grateful for that. And it sounds like we may need to have another conversation in about 90 days because it will be a very different conversation. So I'll invite you now back for that second conversation and tell everybody to stay tuned for that. A special thank you to my colleague, Michelle Galloway, who's always a pleasure to work with, and to the staff at California Lawyers Association. So thank you all. Please have a good day today. Be safe, and we will continue to provide information on the next webinar coming up. So stay tuned. Thank you all.